Next case is PERSAUD versus State.
Morning, Your Honors. Robert Harper III. On behalf of the appellant, with me at council table is Robert Augustus Harper Jr., my father-in-law partner, who apparently thinks I don't have enough white hair, so I'm here to argue before you.
You will soon enough.
Is this the first time we've seen you here?
No, ma'am, but apparently I'm still a work in progress.
Okay. Well, I'm profoundly sorry to hear that.
Your Honor, I think, well, first and foremost, we did not represent Mr. PERSAUD at trial. And in reading over the briefs and the record, I think for purposes of oral argument, it may be best just to suggest that the issue that we have raised is consistent with all three arguments, and that is this is a reliability issue.
And you're focusing on the reliability of the blood test that was done at the hospital, is that correct?
Your Honor, I'm focusing on not only that, but the blood test, the blood sample taken at the scene by law enforcement officers. And the reason why the record is a bit convoluted, to say the least, but I do think trial counsel made some attempt at arguing there just wasn't a sufficient chain of custody. To start with argument one, which would be, I suppose, law enforcement's blood sample.
Could you just help me start understanding the preservation issue? Because as I go through it, I saw this one very vague chain of custody argument, which didn't really seem to have a whole lot behind it, because at least as far as the blood drawn at the scene, the chain seemed to be fine. But I didn't see anything about reliability, although your brief says in it on page 2 of your brief, you said Appellant PERSAUD contends the state's presumption was rebutted by counsel, presumption of reliability. So tell me how you rebutted it. Not you, but trial counsel. Because I didn't see any rebuttal at all. It just seemed like it sailed in without any serious objection.
Well, Your Honor, that may admittedly been a little overzealous to make that statement, but my argument was and is that there's an issue of chain of custody, in my opinion, and with both samples. The law enforcement sample, it was established that trooper arrives, requests that the paramedics conduct a blood draw. That's performed properly. He receives the blood draw, seals it, and puts it in his trunk. But from that point on, all we know is FDLE tested it some 2 weeks later.
But wasn't there a testimony from the FDLE agent that when he or she got the box with the blood sample in it, it was still sealed up and properly marked and all the usual stuff?
There was, Your Honor, but
there was no suggestion of tampering, so I'm trying to understand where your chain of custody is. Is your suggestion that we don't know if it stayed in the guy's trunk for 2 weeks and what happened to it, or is it your suggestion that somebody tampered with it? I mean, I'm trying to understand specifically what your concern is.
Your Honor, my concern with the law enforcement sample is that we don't really know. We do know that
Well, isn't it your job, though, to, if they show that it was sealed up at the scene, was delivered to the lab still in a sealed condition and tested in the ordinary course of business, isn't that enough? And then you now have to come in and show some problem with that?
Well, Your Honor, I think the problem with that is Rule 11D of the Florida Administrative Code requires that if the testing is not performed within 6 days, it must be refrigerated. There must be the inverting of the vials and that sort of thing. What the record reflects is really that none of that was done. There's some evidence from Corporal Weber, I believe, that the blood sample was sent to Ocala, Florida Highway Patrol location. Other than that, it's silent. As it pertains to
But was any of that articulated to the trial judge? Because I didn't see any of that in the record. And maybe I missed
Your Honor,
it.
I think I have to agree with you. The reason why I suggest it's ripe for appellate review is because based on that, the jury is given the presumption instruction, and that's sort of a softball. And therefore, I would suggest that there is.
Did they get the presumption instruction here, or did they just get the instruction that an alternative theory of guilt would be that if he was driving with a blood alcohol of greater than 0.08, that's a crime?
Well,
I thought there's a different instruction that says you can presume if his blood alcohol is greater than 0.08, he's under the influence to the extent he's impaired. But that was that was just for DUI, but they charged him, I thought, in the alternative theory of, unlawful blood alcohol, where they don't have to prove he's impaired or anything. If they can prove he's got an unlawful blood alcohol over 0.08, he's out of luck.
And that's precisely why we've challenged that on appeal.
But what I'm trying to understand is, did the jury in this case get the presumption instruction that says you can presume if he's over a 0.08, he's impaired to the extent his faculties are?
Yes, sir, Your Honor. I think the jury that was instructed on both theories. And my suggestions to you is that if you take one off the table, the whole case changes. When you get to the hospital, I think Mr. Persaud's lawyer certainly did object to the chain of custody. Again, it was a bit convoluted, but it all boils down to reliability. They take him to the ER. A nurse takes a sample, sends it off. A doctor at some point thinks he takes a sample or two, or at least one of his nurses did. That's sent to the lab. And rather than bring the custodian of records, they bring what I suggest is a last-minute certificate and inform the judge. And actually, it was a judge that raised the issue. We have a chain of custody issue, so the state holds up the certificate. Defense lawyer says, I've seen it. And I don't think that proves defense counsel had adequate notice as required under 90.803. A reasonable amount of time in civil cases is 60 days. And while the record is a little unclear as to how much notice defense counsel did receive, I think if you look closely at the record, what he's really arguing, again, is a reliability issue.
If I may,
Please.
Was there a timely objection at trial to the lack of the pretrial notice of intent to rely on the business record under 90.803? And if there wasn't, can you raise it for the first time on appeal?
Well, Your Honor, clearly that's the state's question and argument.
I guess what I'm really searching for is, can you point to me a place in the record where somebody said, I object? There was no pretrial notice of an intent to lie on a business record, and this should not come in without sufficient notice under 90.803.
No, sir, Your Honor. Articulated like that didn't happen. But the reason, again, why I think it's so important to raise this on appeal, and why I think it's still right for appellate review, is because really what all this boils down to is reliability and the ability to confront, authenticate evidence. And what the lawyer did say is that had been taken away from him. And so, as alleged in my brief, he did not use that language. I object to inadequate notice.
Sir, wouldn't we have to find that is fundamental error to overturn the trial court on this particular point?
Yes, sir, Your Honor.
Is there any authority that would be fundamental error, as opposed to just failure to object?
Your Honor, in the context of a confrontation, I think there is plenty. Crawford, for instance. But in the context that you suggest, I would have to concede there is not case law to support that's fundamental error. It certainly could have been objected and articulated better at trial. But when you're dealing with the reliability of evidence and really confrontation or lack thereof, I think that is fundamental error, and you don't have to necessarily contemporaneously object as the state suggests. I see I have about 2 minutes.
Yeah, I was just going to tell you that you're down to about 3 minutes.
I'd like to reserve the remainder. Thank you.
May it please the court, my name is Pam Kohler. I represent the state of Florida in this appeal. As the state argued, none of these issues were preserved. In fact, down below, defense counsel during closing argument basically conceded the state had proved his client guilty beyond a reasonable doubt of DUI and challenged the causation issue rather than the DUI issue. It appears that he was never instructed on the presumption of impairment, which I missed, and I apologize for that. But regardless, under Condaneous, it is never fundamental error according to the Florida Supreme Court. So that's really irrelevant. If this court has no further questions, I ask that you affirm. Thank you.
Thank you. Up again already.
Your Honor, I was told by a wise old man that when it's quiet enough that you hear crickets, it's time to stop. So, thank you.
Thank you, counsel.
Thank you both.